competitive trade practices, which would be highly related, misrepresentations of capabilities in contract negotiations, whether it be with suppliers or vendors or any of the parties that you work with. Getting into detail on one of those, violation of a non-compete is something that we actually see fairly frequently and probably going to see some more often given changes in legislation and how they treat contracts for non-competes. But when you hire an employee away from a competitor, if they've got a non-compete that prevents them from going after a specific industry or a specific territory, not only does that employee have an obligation to honor that non-compete, but the organization that hires them has an obligation to oversee their compliance with that. If an organization has an employee that they know has a non-compete in force, know that it may address certain geographic territories or industries that they may be able to call on, say, in a sales role, but they don't seek to assist and enforce that for their employee, not only will the employee get sued for violating a non-compete contract, but it's likely that the employer could get pursued by their competitor for violating that non-compete and making it possible for that employee to non-compete. And it can be pretty hairy circumstances if your eye is not kept on the ball. Some blind spots in dealing with directors and officers of liability insurance. The assumption that coverage is provided under general liability. It's simply not. Directors and officers liability and some of the other coverages we're talking about deal primarily with financial losses in nature, whereas general liability and auto liability deal more with bodily injury and property damage, and will have specific exclusions for financial type of losses that are going to fall under D&O. The notion that large companies are the only ones that need D&O, whether it's public or 20,000 employees. Reality is, even if you only have 1 or 2 employees under your organization, you can be sued from a directors and officers standpoint because of the decisions and interactions you've got with the outside world. A few other blind spots, and then we'll move on to another coverage. But good relationships and reputation negate the need for coverage. While in a sense that's true and they do prevent some types of suits from coming, some of the worst claims are when good relationships go bad or when high organizations with very good reputations have some kind of misstep where the public or their other stakeholders look at it and they will react very negatively when things hit the press. And then we'll go ahead and move on to employment practices coverage, which is highly related and often purchased in conjunction with directors and officers. Employment practices deals with claims against an organization and its managers that are related to employees, whether it's former, current, or potential employees, and outside individuals with respect to issues such as discrimination, wrongful termination, harassment, and other employment-related allegations. Some claim scenarios we're going to get into. We'll turn over to Garrett to handle.
Thank you, Darren. Excuse me. I wanted to hit really quick in that definition that Darren went over. He had mentioned employees, and where this could affect your organization, this could be future, past, and present employees. The other thing I want to highlight is outside. What that means is that can be third parties. That could be a vendor. That could be a customer. So if you had an employee that was on-site at a vendor or a customer, that's something to keep in mind when we start going over these claim scenarios. So with that being said, let's look at wrongful termination. This is a situation, as we all know, Georgia is an at-will state. So technically, an employer in Georgia does not need reason to terminate an employee. However, there are still protected classes such as race, age, sex, etc. that protect those from discrimination. So it's really important that you have proper documentation, that you take proper notes, that you have proper processes in place to still protect yourself, even in the state of Georgia, even though it's an at-will state for wrongful termination cases. The next scenario I want to look at is sexual harassment of employees. And this would be your employees of your company harassing another employee of your company. That could be a manager harassing a subordinate of his or hers. It could be a subordinate harassing his or her manager. Or it could be a diagonal type situation where a vice president of technology sexually harasses the vice president of finance. The next scenario we want to take a look at is direct sexual harassment by employees. And again, I want to get back to that outside description and the definition we were talking about. So that's that third-party exposure we're talking about. That would be your employees being on site at a third party. So that could be a vendor, that could be a customer. So if you had employees on site at a customer and allegedly one of your employees sexually harassed one of the employees at your customer, that's a huge exposure for industries of any size. The last scenario we want to take a look at, and we're going to detail a little bit on this, is discriminatory hiring practices. So as I mentioned earlier, in protected classes in Georgia, age is an area of protected classes in Georgia. So let's kind of look through a scenario. We've got a 55-year-old and we've got a 30-year-old that a company is in interviewing processes with. The 55-year-old has 30 years of experience in the logistics industry, and the 30-year-old has 5 years of experience in the logistics industry. Both have met the requirements and are looking for the same pay. However, the company goes and decides to go with the 30-year-old instead of the 55-year-old. The 55-year-old, after a few weeks, realizes that they didn't get the job. They ask why they didn't get a job, and all of a sudden they go back to the employer. Unfortunately, the employer did not have any documentation, and the employer ended up getting sued by the 55-year-old that was interviewing for this job. And the reason why they ended up getting sued and this ended up getting into litigation was because they didn't have documentation. So that's a key thing in the employment practice liability, that we need to make sure that we keep documentation, that we have processes in place, and that we try to protect ourselves in every possible way. So I'm going to lead that into the next management liability coverage and exposure, and that's fiduciary liability insurance, and Darren is going to discuss that into detail.
Before we get into fiduciary, I did want to make one comment on the coattails of Garrett. A lot of employment-related practices issues are highly perception-based from the standpoint of the person making the claim. That applies to directors and officers as well, but when it does come to those hiring, firing, disciplinary decisions, understand that you can even have the best practices in place for documenting and going through the processes of hiring and controlling employee behavior. At the end of the day, though, if an employee feels slighted, if a third party feels slighted, they've got the ability to make a claim, and at that point, having good controls in place where you can have documented what actions you've taken and having the right coverage in place is critical. So next we'll move on to fiduciary liability. It's not as commonly known or purchased, and we're going to treat it very briefly because it is not nearly a high exposure item, but it does need addressed. But generally speaking, it covers the liability that can arise from plan fiduciaries who have a responsibility for benefits plans falling under ERISA legislation, and if they misadminister or fail in their fiduciary duty, they can take on liability for your organization and for their personal assets. In today's day and age, the traditional pension has gone away, so 401ks are more the norm. But even in those scenarios, claims can happen, whether it's the selection of a poorly performing 401k on the front end, or there's a mismanagement and administration of how employees participate in it. If something goes south with that plan, the plan fiduciary, even if they didn't have a ton of involvement with the actual results of the plan or the coverage the plan provides under ERISA, they can still be brought into a claim that alleges that they failed in their duty, whether it's failure to properly select an investment option or failure to properly administer benefits and schedule somebody on a health plan to that person's detriment. One key blind spot to remember is this is not what is known as fiduciary dishonesty, which is legally required by ERISA, where plan fiduciaries need to be covered for crime so they can't steal from the plan. They're two highly related coverages, but they are not the same. Fiduciary dishonesty is covered by law or required by law, whereas fiduciary liability is not. It just addresses penalties that can come through the law. Another blind spot is simply the overlooking of fiduciary as a potential coverage that you can secure. It's commonly packaged up with directors and officers and employment practices and almost on a throw-in type basis. Again, the exposure is not huge, but so it can be thrown in with directors and officers and employment practices for often a minimal premium. That's dictated by the size and the complexity of your plans, but it is typically something that's either overlooked or an afterthought that should be considered a little bit farther ahead in the process. The next coverage we're going to move along to is errors and omissions insurance, and I'm going to turn it back over to Garrett.
Thanks, Darren. And we've been getting some questions, and I wanted to actually get back to the employment practices liability. We just got a question, and the question is I have a business with few employees. Do I have an exposure to discrimination and harassment? The answer is yes, in short. And to detail that a little bit, so a small business, let's throw out this example. Let's say you have 5 employees. You have exposure to any of those employees allegedly getting harassed sexually. You could have age discrimination. You could have a lot of different scenarios. Another exposure is, remember back to that third-party exposure, so the outside influences. If you have people in your organization and you have very few people that are working there, those people are also potentially on-site at vendors or customers. So yes, you've got an exposure, even if you are a small business, to harassment and the coverage and exposure to employment practices liability. Okay. So let's dig back into errors and omissions liability insurance. And so this type of coverage, and we're going to later, you may hear it referenced as E&O, and I'm sure some of you in the past have also heard this reference, professional coverage. This coverage provides defense costs, damages arising out of allegation of negligent acts or omissions resulting from a firm's professional activities. And let's just take the audience that we have on here today. It's logistics and supply chain, technology, and transportation professionals. So types of companies within those organizations would be freight brokers, freight forwarders, software developers, consulting companies, warehousing and fulfillment, and customs brokers, and numerous others. You all have an exposure to E&O liability type situations. So let's look at some scenarios here for E&O. The first one being a freight broker fails to follow carrier broker due diligence. So we're all familiar that freight brokers have a process of setting up a trucker with their company. So maybe one of the processes is going onto the Federal Motor Carrier Safety Administration website, checking the carrier's safety basics, checking to make sure the carrier has insurance. And then lastly but not least is getting a carrier broker agreement signed by both parties. So if one of these processes is not met and that affects your end customer, that is an E&O example where instructions have not been followed. A next scenario would be failure to follow written instructions by a warehouse fulfillment operation. And I'm going to detail into that a little bit, so I'll move on to the next one. The next scenario would be customs broker fails to advise proper harmonized classification codes to importer. So anybody involved in the international logistics industry is well aware that commodities have certain harmonized codes, and those harmonized codes give you a duty amount. It may be no duty, it may be 5%. Well, if you are a customs broker and you're advising classifications, and for some reason if the classifications that you advise to your importer are incorrect, you can be brought into a E&O liability situation. So let's go back and let's look at this warehouse fulfillment operation. So what happened in this scenario? A warehouse fulfillment company has a contract with one of their customers. The customer is a chemical manufacturer. And what the chemical manufacturer wanted the warehouse company to do was to label bottles of product that they have. And on the bottles of product, it could be anything from putting a UN number. It could be anything from saying that the chemicals are poisonous. It could be anything to say that the chemicals are flammable. And what had happened with this warehousing company, they had a new employee, and the new employee got trained and did a great job with sending everything out, but they made one mistake on one product that went out the door. They forgot to put the proper label on the product. The product was a flammable product, and they didn't show that the product was flammable. Again, they had instructions from their chemical manufacturer to properly label everything. And what happened is this product, without the proper labeling, went out to the chemical manufacturer's retailer. Retail manufacturer sold it to an end user, and guess what happened? The end user started using the product, lit up a cigarette, and it blew up in his face. And now you've got a $1 million claim situation that happened right now, and it took about a year for this to get back to the warehouse fulfillment company. So the nature of these claims can sometimes take a long time, and that gets into our blind spots. On the blind spots, I want you to take a look at the last section where it says long tail exposure to claims. Again, the nature of these errors and omissions claims is somebody may make a mistake in a process or written instructions or something that their customer has given them instruction. They may not feel the immediate problem until a year, 2 years later. It could be longer than that. So there's a lot of ramifications that can occur due to this long tail exposure. So I'm going to lead this into the next area, which is very related to errors and omissions liability, but that is cyber liability insurance, and Darren is going to discuss this in detail.
Thanks, Garrett. Cyber liability is becoming increasingly common as a topic in the news, but it's often misunderstood. The nature of the coverage is getting to allegations of negligence in handling data that may be owned by your employees or third parties. And it can also include the notifications expenses associated with that, or liability relating out of social media or just media type exposures that you take on by using technology these days. Some common claims, which are fairly broad in how they apply. A computer virus disrupts the ability of your employees to utilize their computers, therefore you can't perform operations for several days. Right there, you've got a scenario where a shutdown in your operations can cause a financial detriment to your suppliers, to your vendors, to your customers, which can result in liability. Another would be just simply the loss of a laptop that contains information, whether it's customers or vendors. Even if that information never gets in the hands of a malicious third party, you may have responsibilities to notify the customers or the vendors of the information that you've lost and let them know there's potential for harm to come to them. Another example, theft of confidential information from a vendor server. We'll touch on a couple implications from this, but if information is stolen from a third party that you've hired to store it, you can still have a liability on it, even if that vendor is responsible for overseeing the information. You're the one that had the original responsibility and information and can take on liability if it's in fact stolen. Theft of physical documents in a warehouse containing personal information or a client's information. A major misconception about cyber liability is that it's purely limited to electronic data, when in reality the genesis of cyber liability came out of concerns over information, whether that's stored in a computer or on physical documents. The loss of that information is the key to where cyber liability rises from. So whether it's in a physical file or on a computer, you can take on liability.
Darren, let me break in there. So if I'm a manufacturer and I'm actually just storing my own documents and they're sitting in my warehouse, do I have exposure to somebody getting personal data, such maybe MVRs, driver information, maybe social security numbers of employees, maybe bank accounts? Would that be an exposure?
And I think you've answered it in the information you provided, but that is the critical nature of this. The information that we store as businesses and operators in our economy is highly sensitive in nature, whether it is employee information for drivers, whether it is personal information of individual customers, or confidential information of your partners in business or even competitors. That information in the hands of the wrong people can do significant damage to those third parties and result in significant damage to you. So it's a great question. Another issue, and we can go through some of the blind spots quickly, but it's definitely rising in importance, but the use of social media and what it can result in. And a great example would be a blog or somebody using a Twitter account that's an employee of yours that's loosely controlled or not controlled at all. They may be thinking that they're doing a great service for your company and may really be getting the word out, but they may make comments that could be considered to be libelous or defamatory towards one of your competitors, even if simply misquoting some of your competitor's capability. Social media and using blogs, using the internet to communicate about yourself and about your competitors basically puts a lot of information out there, if inaccurate, could be perceived very harshly by your competitors. So you need to be very aware of how you're controlling that. And once again, getting back to it, cyber liability does have coverages that do address that. From the blind spot standpoint, we can go over these fairly quickly, but the two main ones I want to address are the misassumption that outsourcing to a vendor relieves you of responsibility. Highly related to that is contractual language can be very detrimental to your organization. If you pick up one of the standard contracts that a lot of data storage companies utilize, they take all liability, relieve themselves of it, ask you to hold them harmless, and take on liability for things that they may very well do incorrectly. That is very key that you are analyzing those documents when you're going into contracts when handling other people's information. With that, we'll move on to the next coverage, which is crime insurance.
Thanks, Darren. So crime insurance, this is coverage for theft of property provided through modular policies that cover employee dishonesty, money and securities, computer fraud, and related coverages. A lot of companies that do have business coverages, such as probably some of you that are on this phone, if you don't purchase a separate crime policy and you don't ask about that, typically what you do get is not as robust of a crime coverage form, and generally the limits of coverage that you would get without purchasing extra coverage are going to be pretty minimal. And the thing to think about in this situation is crime, the way that crime and an occurrence in crime is defined can be, if something happens the same in fashion and form repeatedly day to day over a year span of time, that would be considered one occurrence. So if you had a $5,000 limit that would cover every occurrence, if somebody stole $500 daily, that would rack up some pretty large losses. So to dig into detail a little bit, let's go over some scenarios. So the first one is burglary of goods stored in a warehouse. So this would be somebody that physically breaks into your facility and steals your goods or steals your customers' goods. The opposite of that would be robbery, and that's if somebody came in and potentially put you at gunpoint and they came in and stole something. So different situation right there. The next scenario I'd like to go over would be theft of customer goods by a company driver, and I'll detail into that a little bit. We've picked a little bit on the warehousing and manufacturing community out there a little bit. So next area I want to look at is theft of funds by an organized crime circuit. maybe your industry, maybe the products that you're warehousing are targeted by crime circuits. So you've got an exposure there. The other area we want to look at is daily theft of funds by an employed accountant. So a lot of organizations may have somebody that's worked in their accounting department for a long period of time. Things happen. They may get a ring with an outside person. They may get a ring with another internal person. They've got the ability to change things in systems, and you've got a huge exposure. I've seen a lot of companies, unfortunately, in the last couple of years that have had some very huge losses by somebody internally stealing funds from them. So I want to dig back into theft of customer goods by a company driver. In this situation, a trucking company had a driver that was a problem employee, and he had a bad reputation for performance, and actually this driver was frightened about losing his job. Well, he was dispatched to go pick up a $200,000 load of electronics and then to move it to a retail store. And he knew that his job was on the line, and he was worried he wouldn't get a job from somebody else, so he ended up stealing this load. So he stole a $200,000 load of product, and a couple days later, the end user called up the trucking company to find out where it was at. The trucking company called the driver, and this guy was nowhere to be found. And the trucking company was out $200,000. And the customer wouldn't give up, and they ended up suing the company for $200,000 because the driver stole the goods. That's an example of crime, and that's an example of how that would be covered under a crime insurance policy. So just a couple quick blind spots. If you do have independent contractors out there, you need to be cognizant of how you're covering those on your crime insurance policies. The wording typically in a crime insurance policy does not cover an independent contractor unless those specific individuals are scheduled on the policy. So, quickly look over some of those other blind spots, but in the meantime, I'm going to move over to the next slide, and Darren is going to discuss some miscellaneous insurance coverages that are applicable to the audience today that's on the crowd, just because a lot of us do travel internationally and have some other additional exposures.
The list of coverages here are highly related, and they do relate to the other coverages. We're only going to have a chance to discuss them briefly, but international insurance being the first, whether you have a bricks and mortar location overseas or you're limited just to international travel or exporting, most domestic policies in the U.S. covering standard business insurance, whether it's for general liability or auto liability, are not going to cover an international territory. It's critical that if you do have product going overseas, if you do have employees going overseas, if you have business overseas, that you address that within the policies that you have and seek a source of coverage to expand your general liability and auto liability and workers' compensation overseas. There's some aspects that are not that complicated at all. They just need to be addressed, especially if you're an exporter only. But as you get into locations that you may have overseas or considerable travel and assets that are going to be stored overseas, you really need to start looking into local regulations and be working with somebody that can advise you on how to treat that, because the way that China treats insurance is far different than the UK, it's far different than Spain and other countries. So kidnap, ransom, and extortion insurance. The main thing to say about that is if you're a U.S. company and have employees traveling internationally, despite our economic conditions, we are still have the largest targets on our back because we are and appear to be wealthy individuals, especially if we're traveling overseas. Though it is not a common occurrence, if there were a situation where an employee were to get kidnapped, it could be for a ransom demand of an extremely high amount, and the expenses in hiring somebody to navigate that process could be extremely exorbitant, and that's exactly what this K&R coverage, which is commonly referred to, covers. Crisis management expense is the last coverage I'll mention, but it's more commonly being included within other coverages, say employment practices liability, kidnap and ransom, international. In some Cyber liability is another one, where when you do have a major loss, whether it's your fault or not your fault, there could be considerable public relations issues. That's what crisis management coverage does. Not only does it provide you to cover the expenses of it, but it also helps you to be aligned with folks that can take over instantly and help you manage the situation from an internal perspective. And having known clients that have gone through crisis management issues, the press does not care what really happened. The press cares that they've got a news story. They don't care if you talk to an attorney. In fact, they like it when you talk to an attorney because it adds a little bit of intrigue to the story. Managing that process, though it does not happen often, can be extremely detrimental if handled inappropriately by a company. And with that, we're going to go ahead and wrap up the main part of the discussion. I know that we took a relatively high-level view, but we're more than happy to take some more focused questions if you have them. Again, the coverages that we went over were directors and officers, employment practices liability, fiduciary liability, errors and omissions or professional, cyber, and crime insurance. So unless there's any other comments, we'll turn it over to questions.
I do know we have gotten some questions in, so as we go over a few of these questions now that have come in, you know, please continue to go ahead and send in questions that you have. So the first question that we have, this one went back, let me read this question. If our employees don't have professional licenses, is errors and omissions coverage applicable to our business? So, Darren, I'll throw that one back to you. So basically, the person, I'm not sure what industry or what type of business this person had, but they asked if their employees don't have professional licenses, do they need E&O coverage, or are they susceptible to an E&O type claim?
And I would say the answer to that, without getting too complicated, is yes. It is highly dependent upon the industry that you're in. If there is a higher, typically manufacturing organizations who have their main exposure is products liability, don't necessarily have the errors and omissions exposure that, say, a pure service firm might have. But that is not to say that they do not have an errors and omissions insurance exposure. I think that the key thing is, what is the extent of the services that you're providing, and how much are your clients relying upon them? So just because you have what seems to be a plain vanilla business doesn't mean that you don't have an errors and omissions exposure, but it's definitely something that if you're concerned about it, you can look into further, because within the world of insurance, errors and omissions, especially miscellaneous errors and omissions for various types of service providers, if you have an exposure, they're going to have coverage forms and nuances to that somebody's going to be able to address for you. So hopefully that addresses their question.
Yep. Okay.
Another question we have is, if you hire a 30-year-old due to long-term future management needs of the company, is this age discrimination? Also, what type of documentation would be acceptable regarding the decision? Certainly this question can be held to the end of the session. So from a standpoint of the 30-year-old, and I'll let Garrett chime in as well, this was a scenario where the 30-year-old was hired over the 55-year-old. There's a couple things. Definitely the 30-year-old, if they were hired from a long-term future management needs perspective of the company, I'm not an attorney. I would be careful in that documentation, because when you think about it, the long-term future management needs of the company, it's dicey, because the 55-year-old still has a working career left in front of them. And if you were to document specifically that it was due to long-term future management needs, so you wanted to find somebody that was younger, you're playing with fire a little bit there. That would be a scenario where talking with an employment law attorney would be very helpful, because it is a legitimate decision. At the same time, how you document it and go about it is critical. And I think in the situation, too, that Garrett mentioned, the experience level of the 30-year-old was a little bit less They did technically fit the job requirements that were needed, but the 55-year-old clearly had more industry-related experience. Not sure why the decision would be made like that given the circumstances, but it's been known to happen, and it could very well be age discrimination.
Yeah, I agree with that 100%, and it's a situation. I mean, you really need to make sure any inbound type questions that come from people that you're in a hiring mode with, you need to make sure that those are sent in the proper direction, that you have a certain type of protocol for answering those type of questions, and documentation, just to not to continue to harp on it, that is just majorly a key factor in this whole process. So and a lot of this depends on the state that you're in, and definitely consult an attorney on this type of situation.
But I would say from a standpoint of the documentation, just you've obviously got a job description that has been provided. Any documentation should definitely point to how the candidate meets that job description. And there are legitimate reasons to hire a 30-year-old over a 55-year-old or a 55-year-old over a 30-year-old. And it could be plain business experience. It could be personality. And those are the type of decisions that that need to be documented. The person would be a better fit due to personality or issues of that nature that just bring it overwhelming because, again, getting back to that perception mindset, I could see where a 55-year-old who gets, it doesn't get a job that a 30-year-old gets. I can see where that perception could arise. It is the employer's responsibility to back it up saying, well, yes, we see that perception arises, but here's why we made our decision. Next question. Under the errors and omissions, would the policy cover additional duty if the goods had been classified wrong? You want to handle that, Garrett, or I could?
Sure. Yeah. So in that question, really, with an E&O policy, I mean, the coverage is there to protect you when there is an error made in your advice. So, would the policy cover additional duty if the goods have been classified wrong? I don't want to technically tell you if an underwriter is going to pay a claim, but there's coverage there if the customs broker advises to their importer that a incorrect classification. To be simple.
So ultimately, the chain of responsibility would be the fact that a duty was owed to fulfill the instructions of the client. You failed in that duty. The client suffered an increased expense because of your failure to fulfill that duty, and they can come back and say, hey, we legitimately owed this because of the way that you labeled the product, so we had to pay additional duties. You owe us that money. That's a legitimate claim, and it really gets into policy wording as well.
And ultimately, the importer of records, so the importer in this situation, let's say the textile company, they've got the sole responsibility on this, but they definitely can go back to the customs broker that advised them the incorrect classification. So another question that we have was, what is claims made coverage? That was something that we had discussed originally in some of the first slides. So, Darren, do you want to discuss that quickly? What is claims made coverage?
I can, and I'll try and do it as briefly as possible because it can be a very complex nature. But with directors and officers, employment practices, fiduciary, errors and omissions, they're typically written on what's known as claims made. The reasons for that are what Garrett alluded to before, is the long tail nature of such claims. You can do something today and you may not know about a suit for years to come. So the way that insurance carriers address that is they set up a policy to where coverage is provided not on the policy that was in force when the injury occurred, but when the claims was made or when the claim was made. There is a distinct difference between your standard general liability policy and your auto liability policies when the claim occurs, when the damage occurs, that's the policy that is in force. So the critical nature of that is understanding that because of the way the policies are set up, underwriters expect to know in quite a bit more detail what operations you perform, if you have any potential claims that have occurred in the past that you know about or suspect might be claims, and they have specific time frames on when you must report those. So the biggest implication of claims-made coverage is if you know of a potential claim and you either switch carriers at renewal or you let your policy renew and get into the next several months of coverage, even with the same carrier, and you knew about a potential claim but you didn't tell them at renewal when you were supposed to, you may go to file a claim and you actually get a lawsuit in hand and coverage may not exist. And the company can defend that by saying, you jeopardized our defense of your claim by not notifying us in a timely manner. That varies, and getting back into it, it's a tricky subject because there are different types of claims-made forms, but if you do have these coverages, make sure you understand when claims are supposed to be reported, how they're supposed to be reported, and who reports them, because claims-made coverage can get very tricky. Oh, one last question that we've got, and we're about ready to wrap up. Are defense costs covered within limits or within my limits, which that question is probably coming from somebody that knows a little bit more of these type of coverages. It can vary. Typically, insurance companies like to say, okay, you have $1 million limit, especially with directors and officers' employment practices, and all your defense costs fall under those limits. There's no hard set answer for if defense costs are covered within the limits or in addition to. That's something that you definitely need to clarify on the front end when you're purchasing or renewing a policy, because defense costs can be the largest portion of a loss and oftentimes are. So you don't want to have a low limit policy with defense costs in those limits, because you may not even have room for damages. If you have a policy with defense costs in addition to the limits, the great thing is that your defense costs could go well above your policy limits, but they won't be applied to those limits, so you'll still have that left over for damages in the end. So I hope that answers the questions. And I think that's, from our perspective, it's about time to wrap up. Is there anything that you need to say, Sandy or Paige?
Thank you for joining today. If you have any other last-minute questions, you could send it right now, or you can also go to our website at www.georgialogistics.com. And if something comes to mind later that you're curious about, you can certainly submit it there, and we'll be happy to get back with you. We appreciate you joining us today, and our presentation, this webinar, will be available on our website as well, and the slides will be available for download. And that concludes our webinar. Thank you for joining us today.